They cut the ribbon on 96 brand-new homes while standing on land they didn't own. I stood in the crowd, smiling, holding a manila folder no one noticed. Inside, it was a deed, and the silence that followed in court was louder than their grand opening ever was. People assume abandoned land is ownerless. They see weeds climbing higher than fences, rust on old gates, trees reclaiming gravel paths, and they decide no one is watching, that if a place looks forgotten long enough, it must belong to whoever has the nerve to claim it. That belief has ruined more men than greed ever has, because it replaces caution with confidence. And confidence, when it is unearned, leaves a paper trail soaked in regret. My land sat quietly for years, 38 acres of uneven ground tucked behind what used to be a commercial strip mall that failed before smartphones existed. From the road, it looked useless. From above, it probably looked worse, a patch of green surrounded by concrete, like a mistake the city never corrected. But I knew every inch of it. I knew where the soil turned sandy, where the drainage pooled after rain, where my father once marked a line with a wooden stake and told me never to forget it. He bought the land in the late 90s, right after a zoning fight scared off 3 developers a row. Everyone else saw a problem parcel. He saw patients paying interest. My father believed land didn't lose value. It only waited. When he died, the deed passed me cleanly, quietly without dispute. I filed the paperwork, paid the taxes, and did nothing else. Doing nothing, when done correctly, can be a powerful act. I was already a property attorney by then, specializing in disputes that started with someone saying, "We didn't know." I knew how cities expanded, how HOAs operated, how developers cut corners and hoped the law wouldn't notice until it was too late. I also knew that silence made people careless. So I stayed silent. I let the grass grow tall. I let the old fence lean. I replaced the posted signs only when the law required me to, never when pride demanded it. Years passed without incident. Then one morning, I saw a movement where there shouldn't have been any. I was drinking coffee on my porch when I noticed orange vests flickering through the tree line. At first, I thought the city was surveying nearby roads, but the pattern was wrong. These men were pacing, measuring, driving stakes into ground with practiced rhythm. Surveyors. On my land. I finished my coffee before driving over. There was no rush. Panic clouds memory, and memory is everything in situations like that. When I reached them, I parked deliberately, stepped out, and asked to authorize the work. The man closest to me barely looked up. He gave me the name of a development company and said they were working under Greenstone HOA. He said it like it settled the matter. I told him he was standing on private property. He laughed. Not mockingly, not cruelly, just dismissively. The way people laugh when they believe they're correcting a misunderstanding rather than creating one. He said the parcel had been listed as abandoned for years, that it reverted, that it was free game. I asked him who told him that. He shrugged. I asked for the site manager's name. He gave it to me without concern. I wrote it down. I thanked him. I left. That afternoon, I pulled every document I owned related to land, the original deed, the recorded transfers, tax receipts going back decades, survey maps stamped and approved, zoning correspondence. Nothing was missing. Nothing was ambiguous. My ownership was not just valid. It was boring in how airtight it was. No easements crossed it. No right-of-way touched it. No eminent domain filing had ever been initiated. Greenstone HOA had not made a mistake. They had made an assumption. The next week, machinery arrived. Trees fell. Dirt moved. The sound carried farther than it should have, echoing through the surrounding neighborhoods like a warning no one understood yet. I watched from a distance, documenting everything. Dates, times, equipment, boundaries crossed. I did not confront anyone again. I did not call the city. I did not shout. Instead, I sent one certified letter. It was short, polite, clear. It stated that the land under development was privately owned, included my deed reference number, and demanded immediate cessation of all activity. I sent it to the HOA's registered agent and the development company's legal address. The postal receipts came back signed. No one responded. Construction continued as if I had written a grocery list instead of a legal warning. Foundations were poured. Roads were cut. Utility trenches sliced through soil my father once walked with me, explaining how boundaries mattered more than appearances. I took photographs from public vantage points. I hired a third-party surveyor to document encroachment. I built a timeline. People later asked why I didn't seek an injunction right then. Why I didn't stop them before they got further. The answer is simple and uncomfortable. Early intervention limits damage. And in law, damage is leverage. I did not want inconvenience. I wanted consequences. Greenstone HOA marketed the project aggressively. They called it revitalization. They spoke about unused land and community growth. They implied municipal cooperation without stating it outright. Their language was careful enough to avoid criminal charges and sloppy enough to guarantee civil ones later. Buyers lined up. Contracts were signed. Deposits were taken. I watched every step. By the time framing began on the first houses, I filed a quiet lease pendens against the property. It attached itself to the land like a shadow. Anyone who checked would see it. No one did. Or worse, someone did and chose to ignore it. Months later, banners went up. Balloons followed. A grand opening was announced. 96 homes stood where trees once did, all of them resting on land that had never stopped being mine. The HOA president prepared a speech about vision and opportunity. Realtors practiced smiles. A brass band tuned instruments. I stood across the street, unnoticed, while the ribbon was cut. Inside my briefcase was a deed. Inside my phone were hundreds of photos. Inside the courthouse system was a lawsuit already filed, stamped, and waiting to be served. The sound of applause drifted over freshly laid asphalt, confident and loud. They thought the land had been forgotten. They were wrong. Construction changes the personality of land. What was once quiet becomes impatient. What once absorbed sound begins to throw it back. I could hear Greenstone's progress from miles away, the steady rhythm of machinery rewriting my property line by line. Concrete trucks groaned at dawn. Nail guns snapped like irritated insects. Every sound was a timestamp, and I treated it like one. I adjusted my routine around observation. I drove different routes, parked in different places, never lingering long enough to be remembered. Developers notice resistance quickly. They rarely notice silence. I wanted to be invisible, while the evidence grew heavier by the day. Each slab poured without permission deep in the hole. They were digging for themselves. The first foundations went in fast. Identical rectangles, stamped into the earth with mechanical confidence. I photographed them from the perimeter, matching each pour to the survey overlay I'd commissioned. There was no ambiguity. The encroachment wasn't partial or accidental. They had committed fully, enthusiastically, to land they did not own. Greenstone HOA operated like most do, with committees that diluted responsibility and board members who mistook authority for expertise. Their president, a retired middle manager with fondness for buzzwords, loved visibility. He appeared in promotional videos, hard hat on, speaking about reclaiming and used spaces. I saved every clip. Words matter, especially the wrong ones. By month 3, roads were cut through the property. Asphalt replaced soil, and curbs traced boundaries no planner had the right to define. Utility companies followed, trenching water and power lines across my acreage. Each contractor assumed permission had been granted upstream. No one checked. Assumptions stacked like bricks. I sent no further warnings. One letter was enough. More would have looked like negotiation. I wasn't negotiating. I was documenting. Buyers began touring model homes before drywall was finished. Families walked the lots, imagining futures built on paperwork that didn't exist. I watched from a distance as children ran across lawns that technically belonged to me. It would have been easy to feel sympathy. I didn't allow myself that luxury. Sympathy clouds judgment, and judgment was all I had. Behind the scenes, I was preparing quietly. I opened a dedicated account for costs. I retained outside counsel despite being fully capable of handling the case myself. Distance creates objectivity, and objectivity wins cases. We mapped every cause of action: trespass, unjust enrichment, fraud, slander title. Each claim grew stronger as construction progressed. Greenstone's marketing accelerated. They advertised urgency, limited availability, rapid growth. Realtors pushed buyers to close quickly, citing demand. I recognize the tactic. Speed discourages diligence. No one wants to be the person who slows things down by asking uncomfortable questions. By the time the first closings were scheduled, I filed the lease pendens. Quietly, electronically, it attached to the parcel's legal description, not the HOA's marketing materials. It didn't shout. It whispered. Anyone who searched the title would hear it clearly. No one did, or if someone did, they were overruled by someone louder. Grand opening day arrived wrapped in optimism. Food trucks lined the entrance road. Branded flags flapped in the wind. The HOA board gathered near the clubhouse, congratulating one another like generals surveying a conquered field. I recognized the look. I'd seen it in courtrooms right before verdicts went the other way. I stood among the crowd, unremarkable, listening as the president spoke about community and foresight. He thanked the city. He thanked the developers. He thanked the future residents. He did not thank the landowner. He didn't know there was one. The summons were served before the ribbon hit the ground. Process servers moved efficiently, professionally. One approached the HOA president mid-handshake. Another intercepted the developer's representative near the refreshments. Confusion spread faster than music. Smiles faltered. Phones came out. I left before the speeches ended. Within hours, my phone lit up. Voicemails, emails, messages from numbers I didn't recognize. The tone shifted quickly from confusion to irritation to fear. Greenstone's legal counsel reached out first, proposing a clarifying discussion. I declined. Discussions were for people who still had options. They responded with defenses before even reading the complaint. Clerical error, municipal oversight, implied abandonment, adverse possession. Each argument was weaker than the last. Adverse possession requires time and openness. They had months, not years. Abandonment requires intent. My tax payments alone destroyed that claim. Then they accused me of acting in bad faith. I smiled at that one. Bad faith would have been hiding the deed. Bad faith would have been forging silence. I had warned them. Once. Clearly, they chose to ignore it. The law does not reward willful blindness. Construction halted within days. Machinery froze mid-task. Half-finished homes stood exposed, skeletal frames accusing the sky. Buyers panicked. Banks paused funding. Insurance carriers requested documentation Greenstone could not produce. I filed for injunctive relief to prevent further work. The judge granted it without a hearing. The paperwork spoke for itself. When you build on land you don't own, equity does not rush to your defense. Greenstone requested mediation again. They offered to purchase the land at market value. I rejected it. Market value does not account for 96 houses embedded into soil through trespass. Market value does not punish arrogance. The law allows enhancement. I intended to use it. Behind closed doors, blame erupted. Board members accused developers. Developers blamed surveyors. Surveyors pointed to outdated maps provided by the HOA. Everyone looked for a smaller target to hide behind. No one accepted responsibility. The buyers were the first to understand the depth of the problem. Notices went out explaining temporary legal complications. That phrase is designed to sound solvable. It rarely is. Mortgage approvals expired. Rate locks vanished. Panic replaced excitement. I watched it all unfold with clinical distance. This was no longer about land. It was about process, and process had failed spectacularly. Greenstone's attorneys finally reviewed the deed. Silence followed. In court filings, their tone changed. No more certainty. No more dismissal. They began to hedge, to soften language, to request extensions. I granted none. Deadlines exist to be respected, especially by organizations that claim authority over others. By the end of the month, 96 homes stood unsold, unfinished, and legally homeless. They were monuments to assumption, each one anchored in concrete poured without consent. The HOA's authority evaporated as residents realized the people finding them for lawn height couldn't even prove they owned the ground beneath their feet. And that was before the buyers filed their own lawsuits. I had anticipated it. Class actions loomed. Cross-claims stacked. Greenstone's insurance refused coverage for intentional acts. The developer's bond was insufficient. The city issued statements distancing itself from the project. Everyone stepped back at once, leaving the HOA alone in the crater it created. The court scheduled the first substantive hearing. I prepared calmly, because the law is slow, but it remembers everything. And Greenstone had left fingerprints on every inch of my land. They thought the worst part was losing the land. They didn't realize the buyers were about to learn who really owned their homes, and who they'd be suing next. Courtrooms have a smell. Old paper, polished wood, recycled air, and anxiety. I noticed at the moment I walked in, briefcase in hand, posture relaxed, heart steady. I had been in court hundreds of times, usually arguing on behalf of people who found themselves on the wrong side of a document they never bothered to read. This time, I was there for myself, and that changed nothing except the satisfaction. The gallery was full. HOA board members sat together, no longer smiling, whispering like students who knew the test had already started. The developer's representatives occupied the second row, eyes fixed forward, hands folded tightly enough to whiten knuckles. Realtors sat scattered, pretending not to recognize one another, and behind them, the buyers. Families who had imagined futures and now face uncertainty. They looked tired, betrayed, and desperate for someone to blame. The judge entered without ceremony. She was known for efficiency and a low tolerance for theatrics. I respected that. The law does not need drama to be devastating. Greenstone's attorney stood first. He spoke carefully, deliberately, as though tone alone might soften facts. He argued municipal confusion, outdated records, good faith reliance. He said the land had appeared abandoned. He said the HOA acted reasonably. He avoided the word ownership as long as he could. When it was my turn, I stood and spoke plainly. I introduced myself, stated my standing, and presented the deed, not a copy. The original, recorded and certified. I handed it to the clerk, who passed it to the bench. The judge read silently, then compared it to filings before her. She looked up. "Counsel," she said to Greenstone's attorney, "your clients never owned this land." The sentence landed hard. It did not accuse. It did not insult. It simply stated reality. Murmurs rippled through the gallery. The buyers leaned forward. The HOA president stared at the floor. Greenstone's attorney attempted to pivot. He raised adverse possession. I dismantled it point by point. Time requirement unmet. Possession not exclusive. Notice insufficient. Taxes unpaid. Each element missing. The judge nodded as I spoke, not because she agreed with me, but because the law did. They raised abandonment. I submitted tax receipts, maintenance records, correspondence. Abandonment requires intent. My continued compliance destroyed that argument entirely. They suggested implied municipal transfer. I requested documentation. None existed. The city was never a party to the land. Assumption, again, was their only evidence. The judge ruled from the bench on several preliminary matters. Trespass established. Ownership confirmed. Injunctive relief upheld. Construction permanently halted pending resolution. Each ruling stripped another layer of protection from Greenstone's already exposed position. Then came the buyer's attorney. He filed motions to intervene, alleging fraud, misrepresentation, and negligent conveyance. The judge granted intervention immediately. Greenstone's legal team stiffened. They were no longer facing one plaintiff. They were facing dozens. The developer attempted to distance itself, claiming reliance on HOA representations. The HOA claimed reliance on surveyors. The surveyors produced emails showing HOA-provided boundaries. Responsibilities circled back like a blade. I watched it unfold with detached clarity. This was not chaos. It was causality. The judge scheduled a full evidentiary hearing and encouraged settlement discussions. She did not order them. She suggested them like a warning. Greenstone's attorney asked for mediation. I agreed to attend, not to concede. The mediation room was smaller, quieter, stripped of ceremony. Without the bench, Confidence eroded faster. Greenstone offered to purchase the land at market value. I declined. They raised the number. I declined again. They argued fairness. I argued enhancement. The law was on my side, and they knew it. By the end of the day, no agreement was reached. Outside, reporters waited. I declined comment. Silence had served me well so far. I saw the HOA president give a shaky statement about ongoing legal processes. He looked smaller than he had at the grand opening, diminished by the weight of consequences. Weeks passed. Motions flew. Discovery unearthed emails revealing internal doubts ignored in favor of speed. A board member had questioned ownership early on. He was overruled. That email became an exhibit. Confidence, again, proved expensive. Depositions followed. I watched the HOA president struggle to explain why no title search had been performed. We trusted our consultants, he said. Trust is not a defense. It is an admission. The developer's project manager admitted deadlines drove decisions. Realtors admitted they were instructed not to confuse buyers with unnecessary legal detail. Each statement tightened the net. The evidentiary hearing arrived like a reckoning. Witnesses testified. Documents were entered. Timelines aligned with painful precision. The judge listened, asked pointed questions, and took notes. When it was over, she thanked everyone and took the matter under advisement. Her ruling came 3 days later. Ownership affirmed. Trespass damages awarded. Constructive trust imposed. Greenstone ordered to either remove all structures or compensate the landowner at enhanced value, reflecting improvements. Attorney's fees granted. Costs assigned. Liability established. Greenstone's attorney closed his eyes when the ruling was read. The buyers exhaled, some in relief, others in anger. They now knew who to sue next. Greenstone did not appeal. Appeals require hope. They had none. Settlement negotiations resumed, this time without bravado. Numbers grew realistic. Offers included land purchase, damages, fees, and penalties. I listened. I calculated. I countered. We reached agreement weeks later. The land would be sold at triple market value. Damages paid. Fees covered. A public correction issued. The HOA dissolved as part of the settlement. Its authority stripped. Its board disbanded. The judge approved it without comment. As I left the courthouse for the last time, I felt no triumph, only closure. The law had done what it always does when given patience and proof. It corrected arrogance with accuracy. Paper beat concrete. And the lesson would last longer than any house ever built there. Victory in court doesn't sound like cheering. It sounds like phones ringing unanswered, offices closing early, and people realizing too late that consequences don't negotiate. The ruling didn't just hit Greenstone HOA. It rippled outward, cracking everything built on their confidence. By the next morning, the development felt abandoned in a way my land never had. Silence replaced machinery. Uncertainty replaced sales pitches. The buyers were the first to move. They had waited, hoping the HOA would fix things quietly, hoping the court would somehow validate their purchases without pain. When the ruling became public record, hope turned into urgency. Attorneys were hired. Complaints were drafted. Class actions took shape, like storm fronts gathering strength. Greenstone's inbox flooded with demands they could neither answer nor afford. I received calls too. Buyers wanted explanations, reassurance, solutions. I spoke carefully. I did not gloat. I did not assign blame. I explained the law, the process, and their options. Some thanked me. Others accused me of waiting too long. I understood both reactions. Pain looks for a target, and proximity often wins. Banks reacted faster than anyone. Mortgage approvals were withdrawn. Construction loans defaulted. Rate locks expired. Financial institutions hate uncertainty. And Greenstone had turned it into an art form. Insurance carriers followed, issuing reservation of rights letters before denying coverage outright. Intentional acts, after all, are rarely insured. The developer attempted damage control. Press releases spoke of unforeseen complications and ongoing discussions. Internally, emails told a different story. They scrambled to shift liability, pointing fingers at surveyors, subcontractors, anyone with a signature they could drag into court. Third-party complaints multiplied. Dockets filled. Greenstone's board fractured under pressure. Emergency meetings devolved into shouting matches. Members resigned mid-session. The president tried to hold the line, insisting resolution was still possible. He believed authority could substitute for solvency. It couldn't. Authority dissolves quickly when backed by nothing but unpaid invoices. The city issued a statement distancing itself from the project. Permits, they said, had been issued based on representations made by the HOA. No ownership verification was required at that stage. The implication was clear. The city would not share blame. Municipalities rarely do. The development itself began to decay in real time. Exposed framing weathered. Unfinished roofs leaked. Vandalism crept in, slow at first, then bolder. Security was cut when invoices went unpaid. Windows shattered. Graffiti appeared. What had been marketed as a dream became a liability visible from the road. I walked the perimeter once. Weeks after the ruling, the place fell hollow. 96 houses stood incomplete. Identical shells of optimism turned cautionary tale. I felt no satisfaction, only a strange detachment. This was never about destruction. It was about correction. Settlement talks intensified. Greenstone's attorneys came prepared now, armed with spreadsheets instead of slogans. They proposed land purchase at increased value, damages, and fees. I countered with enhancement, reflecting the improvements permanently affixed to the land. Concrete utilities, roads. Each added value they could not reclaim without further loss. The law recognized that reality. Behind closed doors, the HOA's financial position collapsed. Reserves were drained. Special assessments were proposed, then abandoned when residents refused to pay for mistakes they hadn't made. Collection authority meant nothing without credibility. Vendors filed liens. Employees quit. The HOA existed in name only, a corporate shell rattling in the wind. The buyers' lawsuits moved forward aggressively. Depositions revealed misrepresentations repeated as fact. Sales scripts instructed agents to downplay legal questions. Marketing materials implied ownership without stating it outright. Judges do not appreciate implication used as camouflage. Summary judgments followed. I testified once, briefly. Ownership. Notice. Silence. I answered questions calmly, precisely. The buyer's attorneys didn't treat me as an adversary. They treated me as evidence. That was fine. Facts don't take sides. They simply exist. Eventually, the numbers force reality. Greenstone could not survive prolonged litigation. The developer could not absorb total liability alone. A global settlement emerged as the only path forward. Negotiations stretched for days, then weeks. Every dollar was argued, every clause dissected. The final agreement was comprehensive. Greenstone would purchase the land at triple market value. Damages would be paid. Legal fees covered. Buyers would receive compensation through a structured fund financed by the developer and its insurers. The HOA would dissolve permanently, its authority terminated, its charter revoked. A public correction would be issued acknowledging the error. When the judge approved the settlement, no one smiled. Relief replaced tension, but it was quiet, subdued. Some losses cannot be fully repaid. Trust, once broken, rarely returns intact. Implementation took months. Deeds transferred, funds dispersed. Liens cleared. The development was replatted under new ownership. Construction resumed eventually, slower, more cautious, watched by regulators who now knew the address by heart. Greenstone HOA disappeared. Its website went dark. Its signage was removed. Its board scattered, reputations damaged, confidence shattered. They became a case study whispered about in planning meetings and legal seminars. A warning disguised as history. I received my compensation without ceremony. Numbers on a page. Transfers completed. The land, now transformed, passed in new hands under terms I approved. My father's patience had paid off, compounded by arrogance I never invited but fully addressed. Sometimes people ask if I regret not stopping it sooner. I tell them regret assumes obligation. I had no obligation to save an organization from its own decisions. The law provided a path. I followed it precisely. What stays with me isn't the money or the ruling. It's the moment assumptions collapsed under scrutiny. The realization that confidence without verification is just hope wearing a suit. Greenstone learned that lesson publicly. Others learned it quietly. The houses still stand today, occupied now, normalized, their origin story fading with time. Children play in yards once disputed. Life moves forward. It always does. But beneath the pavement, beneath the utilities, beneath every poured foundation, there's a lesson pressed into the soil. Ownership matters. Paper matters. Silence does not mean surrender. And land, no matter how quiet it looks, remembers exactly who owns it. Time has a way of smoothing sharp edges. What once felt like crisis becomes story, then memory, then something people reference vaguely without understanding its weight. By the time the last document was filed and the final transfer recorded, the Greenstone matter had already begun to fade from public conversation. That was fine with me. Loud endings are overrated. Quiet conclusions last longer. I returned to my normal work not long after the settlement closed. Same office, same clients, same disputes rooted in assumptions someone should have questioned earlier. Every now and then, a colleague would bring up the case, usually with a tone that suggested admiration mixed with disbelief. They always asked the same question, just phrased differently. How did they not check? I never had a satisfying answer. Some mistakes are too large to explain simply. They are built gradually, decision by decision, until reversing course feels more painful than continuing forward. Greenstone did wake up one day and decide to trespass. They woke up every day and decided not to verify. I drove past the development occasionally, not out of nostalgia, but out of habit. Lawyers develop habits like that. The roads were finished now, lawns trimmed, mailboxes installed. Children's bikes lay on driveways that once sat on soil my father walked with careful steps. If you didn't know the history, you'd never guess anything had gone wrong there. That's how thoroughly systems repair themselves once pressure is released. I didn't stop. I never felt the need to. What stayed with me wasn't the scale of the mistake, but how ordinary it was. No villain twirling a mustache. No secret conspiracy. Just a chain of people assuming someone else had done the boring work. Title searches are boring. Tax verification is boring. Reading plats is boring. Boring work prevents spectacular failure. And spectacular failure is exactly what people invite when they skip it. The HOA dissolved quietly. No ceremony. No final meeting. The corporation simply ceased to exist like so many before it. Its former board members scattered into private life. Some chastened, some bitter. Some convinced they were unlucky rather than wrong. I've learned not to argue with that kind of thinking. It resists evidence. The buyers moved on too. Most stayed. Some sold the moment they could. Lawsuits settled, money distributed, anger dulled by time. A few sent letters months later, thanking me for answering questions honestly when no one else would. I kept those letters in a drawer I rarely open. Gratitude is heavier than blame. It demands more care. People assume I must have felt vindicated. In truth, vindication implies emotional investment. I never allowed myself that. From the moment I saw the survey stakes, I treated the situation like a case file. Facts in, strategy out. Emotion kept at a distance where it couldn't interfere. That distance is what made silence possible. Silence is often misunderstood. People think it means weakness, hesitation, fear. In law, silence can be leverage if it's paired with preparation. Every day I said nothing, they said more. Every week I waited, they poured more concrete. Every month that passed, their exposure deepened while my position remained unchanged. Silence gave them room to commit. That's the part that unsettles people most when they hear the story. They imagine themselves shouting, warning, demanding. They imagine stopping the mistake early, saving everyone trouble. What they miss is that early intervention would have rewritten responsibility. It would have allowed Greenstone to claim confusion, cooperation, mitigation. By waiting, I preserve clarity. The law thrives on clarity. I never lied. I never concealed ownership. I paid taxes openly. I filed records properly. I sent notice. Once, That was enough. After that, every decision was theirs alone. Silence did not create the problem. It revealed it. There's a misconception that justice requires urgency. It doesn't. It requires precision. Urgency often benefits the party already in the wrong. Precision benefits the one who waited to be certain. My father used to say land teaches patience to people willing to listen. At the time, I thought it was just something men said when they wanted to sound wise. Now I understand what he meant. Land outlasts panic. It rewards those who respect process. It punishes those who mistake appearance for authority. When Greenstone's president shook hands at that grand opening, he believed the moment belonged to him. In a way, it did. That moment captured everything about the mistake. Confidence untested, authority assumed, ownership ignored. I didn't need to interrupt it. I needed to preserve it. Evidence is most powerful when it's allowed to exist naturally. I keep the original deed in a safe now, alongside my father's notes. I don't take it out often. There's no need. Its work is done. Ownership doesn't need reminders when it's been respected again. Occasionally, a client will bring me a dispute involving an HOA or a developer pushing boundaries. They'll ask how aggressive they should be, how loud, how fast. I give them the same answer every time. First, be right, then be patient. It's not advice people like hearing. Patience feels passive. It isn't. It's controlled restraint, guided by certainty. Without certainty, patience is just delay. With certainty, it's strategy. Greenstone taught a lot of people that lesson, whether they wanted it or not. Planning departments updated checklists. Lenders adjusted verification requirements. Title companies circulated internal memos referencing the case without naming it. Quiet changes, invisible to most, but real. That's how systems learn. Not from lectures, but from loss. As for me, I went back to my life unchanged on the surface. Same routines. Same office lights humming late at night. Same files stacked neatly, each one a story waiting to happen. But I carried a deeper confirmation with me. Proof that the law, when allowed to work without interference, still does exactly what it promises. It doesn't rush. It doesn't bluff. It doesn't care how impressive the structure looks from the outside. It cares about paper. Process. Proof. Greenstone built houses. I held a deed. In the end, that was enough. Silence, it turns out, is worth quite a lot when you know exactly when to break it.